Brian Bowling on behalf of Mr. Newcomb, Your Honor. State your name for the record, please, sir.
Thank you. Have spelled several names in all the paperwork. I don't know what you want to do. That's how it's treated. That's why it's contested. And I named several ways in all the paperwork. You can talk about the defendant's office and in jail. I don't know what name you like to do.
What name do you go by?
I go by British.
Okay. Have you ever gone by Sean? Have you ever gone by Sean Newcomb?
They have it spelled, like I said, several different ways on all the paperwork. S-E-A-N and S-H-A-W. And that's most of the paperwork. I have a letter from the public defender's office. The envelope has it spelled S-E-A-N. The letter inside has it spelled S-H-A-W-N. They have spelled in many different ways. I don't know what you want to use. It's not my fault, it's your failure.
Okay. No, we'll accept that failure. And I will indicate that to the best of the court's knowledge, we'll proceed with this understanding the person I know to be, or not know to be, but is Sean Newcomb. All right.
Right out of the gate, this hearing is already spiraling into one of those courtroom exchanges where everybody in the room realizes I's normal procedure just left the building. The defendant is arguing over multiple spellings of his own name. Tensions are rising immediately, and Judge Simpson is trying to keep the proceeding anchored in reality while also making an official court record that actually makes sense. And notice the judge's tone here. Calm, measured, but clearly aware this situation is drifting into dangerous territory fast. Then comes the real turning point. Defense counsel signals concerns about competency. That changes everything. Once competency enters the conversation, the courtroom stops being about guilt or innocence and starts focusing on whether the defendant can even properly understand the proceedings against him. That is a massive legal shift. What also stands out is how quickly the atmosphere changes from confusion to caution. 1 minute, it sounds like a bizarre identity dispute, and the next minute, the court is ordering a forensic evaluation. That's not routine paperwork. That's the court essentially saying, we need experts involved before this case can move forward responsibly. And if you're watching this unfold, you can already tell this hearing is setting the tone for the chaos that follows later in the docket. Because once emotions, confusion, and courtroom management issues start stacking together like this, things rarely settle down quietly.
Your Honor, based on my interaction with Mr. Newcomb yesterday at the jail and this morning in the lockup, I believe I'm required to request a competency evaluation in this matter.
Forensic evaluation will be ordered. I'll need the orders. I have those, so you'll need to supply those to me.
I'm working on it with the case call.
All right. I'll set a competency hearing in this case for July 17th, 2025, 9 a.m. This time the defendant's bond is continued. Thank you.
Thank you, Judge.
Oh, that's it. His bond's revoked. Hold it. Don't go anywhere near. We got to get somebody in here because somebody's got to clean that up. Court's going to stand in recess. Case People versus Adam Watkins.
Conrad Siller on behalf of Pittsfield Township.
Kyle Burdell on behalf of Mr. Watkins. Mr. Watkins, please say your name. Once you get up here. Oh, sorry. Adam Watkins.
All right. What are we doing on this?
You got a day's date and time set for pretrial. Prosecutor Siller has extended an offer whereby if Mr. Watkins completes drug treatment as part of the sentencing on another case in Canton, he'll dismiss this case. And he wants to take him up on that offer. So Judge, we would like to be heard as to bond. First of all, we're asking for an adjournment, and then when the court deems it appropriate, we'd like to be heard as to bond.
Well, when is the treatment?
So you've already been sentenced, correct?
Yes.
And you're supposed to start treatment next week?
Before the 16th.
Yes.
The only thing prevent me is this right now. I'd already be there.
Yeah.
Now the courtroom shifts into an entirely different type of frustration. The kind where everybody keeps talking about treatment, but nobody can actually provide the court with the most important detail, where the treatment is supposed to happen. And Judge Simpson is clearly losing patience with the lack of concrete answers. Listen carefully to what's happening here. The defendant is insisting he wants rehab. The attorneys are discussing treatment opportunities. The prosecution is willing to consider dismissal tied to compliance. But every time the judge asks a direct logistical question, fussibility name, 5 reporting instructions, verification. Nobody has the information ready. That is a huge problem in court. Judges do not operate on I think, maybe, or someone might know. They operate on verified facts and documented conditions. 5. And from the judge's perspective, this becomes a credibility issue fast. If somebody is genuinely ready to begin treatment, courts expect specifics, dates, locations, intake confirmations, probation instructions, something tangible. Instead, this hearing keeps circling back to uncertainty.
Because of the issues that's involved in that. But where is he going to be doing treatment?
Wayne County.
Okay, that's
What facility?
I'm not sure. I've not been able. I went to court the day before I came to see you, so if I can get out there, I'll go to Canton today, and I don't know the facility yet, Your Honor.
Okay, so we're at the same spot that we were last week. And I put it to today's date so somebody could figure out where he's supposed to do treatment.
Yes, sir.
I'm not opposed to his release regarding treatment, but
The facility. You don't know.
My mother may know. I do not know. I was supposed to contact the probation department in Canton, and I've not been able to do that because I've been here. My goal is to get into rehab and start a new phase of life. I mean, I can't do it. I've not been able to contact the facility. From my understanding, Wayne County has a distribution center. I have to call that number. And once I call that number, they'll find me a bed. I've not been able to do that because I have not got the number yet. As soon as I came to court here with MCU, and I've been here.
We have proof that that's even his sentence.
Your Honor, I believe it's on the ROA. I tried to get in touch with his attorney. I reached out. I wasn't able to get in contact with the attorney. His mother's here.
I'm sorry. Can I interject?
You already have. Go ahead.
Assistant Public Defender Lauren Kearney. Your Honor, I'm not hearing on behalf of Mr. Watkins because we did conflict out on the case. However, I did contact Mr. Watkins' attorney prior to conflicting out.
His attorney in Canton.
In the 35th District Court, right. He did provide me with the judgment of sentence. It says, and I'll just read the full thing. The defendant shall serve 30 days in jail for failure to pay on time as part of the additional sentence. Prior to enforcement, the court will determine the defendant's ability to pay. Okay. Other shall be confined to jail for 30 days, jail for complete residential treatment concurrent with, and it references another case.
This is where the hearing turns from messy into legally tangled. 5. Because now the court is digging through sentencing language in real time, trying to figure out what exactly another court already ordered. And honestly, you can hear Judge Simpson becoming increasingly skeptical, as every explanation seems to create even more confusion instead of clarity. The key issue here is the phrase concurrent with another case. That immediately raises alarms, because now the judge is trying to determine whether there's an additional sentence, another jurisdiction involved, or some other unresolved matter floating around in the background. And the worst thing you can do in front of a judge is appear unprepared about another active case tied to the defendant's custody status. What makes this especially dramatic is that nobody in the room seems fully aligned. One attorney references another case. Another tries correcting the explanation. The defendant insists everything was handled already. Meanwhile, Judge Simpson is basically forced into detective mode, trying to reconstruct the legal picture piece by piece. And this is exactly why courtroom credibility matters so much. Judges can handle bad facts. What they hate is incomplete facts. Because incomplete information creates risk. And courts are not in the business of gambling with public safety, release conditions, or sentencing compliance.
I can provide the full...
Well, okay, but what's that other case then?
That is that's an OWI in controlled substance case, Judge.
Has he been sentenced on that?
That's the case where we're discussing, Judge. That is the sentence for that case.
I'm sorry, no, I'm...
No.
Oh, was that a different case?
The sentence for the 35th District possession of paraphernalia.
Okay.
It does say the defendant to report to Washington WCJ, which is
sorry, you're right.
County Jail, Criminal Justice Center on 6/19/2025.
I remember that.
Right.
So all I'm getting from this every time he shows up is there's another case. Because the first time there was that case that you're referring to, because
Right.
you gave me part of that sentence recommendation, I think last week.
Right.
But now the sentence he has is concurrent with another case.
Yeah, unfortunately, I don't know anything
was-
about the other case.
I misspoke, Judge. That is his only case out of 35th District that I'm aware of. I misspoke, Judge.
Yeah.
I believe that's his only case out of 35th District.
Okay, it's fine.
Yes.
Except that he got sentenced on a case. Part of his sentence is a concurrent sentence with another case. I don't know what that other case is.
I can try to find it.
Judge, I couldn't find any other cases. I'm trying to get in touch with his Canton attorney to try to clear that up.
At this point, you can practically feel Judge Simpson's frustration building through the courtroom. The hearing has now reached that dangerous zone where the court keeps hearing references to another case, yet nobody can clearly explain what that case actually is, whether it's resolved, or how it impacts the defendant's treatment eligibility. That's a nightmare scenario for any judge trying to make a release decision. And notice how the courtroom dynamic changes here. Earlier, the discussion sounded hopeful: treatment, rehabilitation, second chances. But now the conversation is dominated by uncertainty. Different attorneys are referencing different records, case numbers are getting thrown around, and even the court seems unsure whether everyone is talking about the same matter. This is also where defendants sometimes unintentionally hurt themselves in court. Even if someone genuinely wants help, confusion surrounding their legal history can make judges hesitate. Courts rely heavily on structure, documentation, and accountability. If the paperwork is unclear, the judge often assumes the risk is unclear too.
But I didn't see that.
Ask my mother, she has his card.
I can't do that right now. We'll do that after.
So nobody knows about this other case.
I haven't found any information on it. Mr. Watkins is insisting he doesn't have another case.
I took care of everything.
So, Mr. Parney, the section that you just read said he was sentenced to something concurrent with.
Yeah, the case number is, again, it's Canton, so I don't know how to, out of my own, but 24C08295B.
John, that may be an old ticket.
It does sound like that. I mean,
Yeah, he did.
typically how we pay some of our tickets here, but again,
I just swore I took care of everything when I was in court, and my understanding.
All right, look, folks, somebody get me some information that that's what's supposed to happen. That's what was supposed. That's why I adjourned it out a week. Put it at an odd time. So you give me information that indeed he is supposed to go into treatment in the manner in which he said, or that there's a specific name of a facility. I'm here a week later. I don't have that.
Yes, and Judge, was that a dangerous drugs case? Oh, was that a felony?
No, I don't.
This is so hard.
And Judge, Judge, for the record, I was not here at that last one. I was just recently appointed. This is my first pretrial, so thought I was up to date on it, but apparently I need to.
Apparently not.
Yes, apparently not.
You know a hearing has officially gone sideways when the judge starts openly commenting on how dramatically people are closing their laptops. And somehow, despite the tension in this courtroom, Judge Simpson still slips in sharp sarcasm while trying to regain control of the discussion. But underneath the humor, there's a serious issue brewing. The court still does not have verified treatment placement information, still does not fully understand the overlap between the defendant's cases, and still lacks confidence that anyone has a complete handle on the situation. That's why the judge keeps pressing everyone for specifics instead of assumptions. And honestly, this exchange highlights one of the toughest realities inside criminal courtrooms. Cases don't slow down just because communication between attorneys breaks down. Judges still expect preparation. They still expect accurate records. They still expect answers. What's fascinating here is that Judge Simpson's patience hasn't completely disappeared yet. You can hear irritation. Absolutely. But you can also hear the judge continuing to search for a lawful pathway forward instead of immediately shutting the door.
Well, Your Honor, I mean, I suppose we could.
What, Barney? Was there anything you wanted to tell me? Or I mean, you closed the computer, but I don't.
Dramatically.
She's mad at you?
No, I said dramatically. She may be. You know, I wouldn't blame her.
It says the same type of thing, Your Honor. Township of Canton v. Watkins.
Yeah.
Judge Giroux, 6/20/25, scheduled to report to jail.
Yeah, that's
Court, it's an ordinance.
Can somebody get
Misdemeanor.
in contact with his attorneys out there or get in contact with the court out there to let it know, Miss Polari, you have written. You are probably going to clear something up for me.
Well, I can tell you, I used to see 2 cases out of the 35th District Court.
Thank you.
One is the possession of drug paraphernalia. The other is possession of dangerous drugs. It does indicate.
So he has another, right.
But it's not pending, but you've been sentenced on it?
Yes.
Okay, he has been sentenced on it.
It does reference, Your Honor, the same that he's to report to jail on both of those cases. So I believe that he's disposed.
Got it. But he's supposed to do treatment in lieu of reporting to jail on both of them.
Correct.
So can somebody find out for me where he's supposed to do treatment? He's saying it's a distribution center. I understand what he's saying makes some sense, but nobody seems to be able to verify that for me.
Your Honor, would you like me to reach out to that probation officer? I can.
You know, Miss Polari, that's why I've missed you. Because otherwise what I've had to do is I've had to listen to these 2 attorneys who told me nothing. Miss Perroni just read to me, which is fine. Nice voice, but still.
I can reach out to that probation officer. Your Honor.
All right. So what I will do is I will adjourn it out a week. I may consider, okay, or I don't have to.
Oh, it's okay. He's just eager to get on a treatment, Judge, and a very expressive.
No, he's eager to get out.
No, just it's okay. It's okay.
Did I finish now?
Yes, Judge.
I'll adjourn it out a week. What I was then going to say is, if I receive verification of what's being said, I will consider release prior to that date. If he acts that way in my courtroom again, I'm not going to do that.
Thank you, Judge. I will have a talk.
So I will adjourn this out to the 19th.
And there it is, the final ruling direction from Judge Simpson after nearly an entire hearing filled with missing information, 5 contradictory explanations, uncertain case records, and repeated confusion about treatment placement. The judge ultimately decides to adjourn the matter another week. But this was not some easygoing continuance. This came with a very direct warning attached. Judge Simpson makes it crystal clear. Verification matters. If the court receives proper confirmation about treatment arrangements and sentencing compliance, release may still be considered. 5. But if the defendant continues interrupting or behaving disruptively in court, that possibility disappears fast. That final warning about courtroom behavior was not casual. It was the judge drawing a hard boundary. And honestly, that became the core theme of this entire proceeding. Not just treatment, not just bond, accountability. The court repeatedly asked for proof, 5 structure, and reliable information. Every delay in answers increased the judge's concern. Every inconsistency created more hesitation. At the same time, you can also see the court trying to leave the door open for rehabilitation if the defendant and counsel can finally provide concrete verification, instead of confusion. That balance between caution and opportunity is something judges deal with every single day. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.